SJC-11584, Floor Ortiz via Examworks, Inc.
Good morning, Mr. Lamoth. You may begin.
Good morning, Your Honors. May it please the Court, Matthew Lamoth for the plaintiff and the class. Your Honors, this case is about a class of people who were deceived into expending personal time and coerced into submitting to physical examinations of their bodies at the hands of another individual who lacked the authority to conduct the exam, according to the legislature and the lower court.
Could you explain how they were deceived? Didn't the notice that they get make it clear that this was not an MD who was doing the examination?
Well, Your Honor, I think the notice is anything but clear. It does qualify Mr. Boglin as an examining physician.
But then it goes, Richard, is that his first name? Whatever his first name is.
Eugene.
Eugene Boglin, DPT, and it has a couple of other, none of them is MD. None of those initials is MD. And at that time, your client was represented by counsel, so even if he didn't know, one would think counsel would know.
Well, Your Honor, that gets to the causation, and to see it otherwise would be to presume that both Mr. Ortiz and his counsel knew that Mr. Boglin was not a doctor, and then Mr. Ortiz still appeared at the IME. And I think under the standard and under the pleadings, the averments and the complaint, it's more reasonable to infer that they were in fact deceived by the use of the word physician on the notice. And this is because, as I was trying to make clear, there would be no reason for Mr. Ortiz and also his attorney to appear at the IME, or his attorney to advise him to appear at the IME if they knew he was not, Mr. Boglin was not a physician.
Does that go ahead. Does that argument go away if we interpret the statute as including individuals such as those who perform the examination here, so that you would be on notice of the statute regardless of what individuals might subjectively assume?
Yes, Justice Duffley, I think if the case does turn on whether or not a physician includes or does not include physical therapists for the purposes of 9034M. The appellant's position is in harmony with the Superior Court in this case, as well as a very similar case recently decided by the Appeals Court, where a physician does not, or a PT does not qualify as a physician for the purposes of the PIP statute. I think the reasoning in the lower court's decision is sound, and it explains why we should not characterize or include physical therapists as physicians for the purposes of the PIP statute, particularly for the purposes of IMEs. And just to elaborate on that point, seeing as I do believe it is, as you have suggested, a first and foremost hurdle, there are obviously much more rigorous requirements to becoming an MD as compared to a physical therapist. And it's the appellant's position that it follows to require a physician who has gone to medical school and passed the medical boards to be the authority on whether or not an individual needs more medical treatment.
Would you say the same if the accident caused the person to lose 13 teeth? Wouldn't you want a dentist?
I think that a dentist and a medical doctor have very similar if requirements in terms of licensing and medical school and board examinations, but I do believe that, if anything, to limit it just to a medical doctor would make sense because of it being the highest authority, a medical doctor. A medical doctor would presumably have sufficient expertise on that just by getting through med school
I
and
don't think
passing the
I'm going
boards.
to have my teeth fixed by my primary care physician.
Well, Your Honor, this case is also still specifically limited to a comparison between medical doctors and physical therapists. If the court was to conclude that a dentist does qualify as a physician, the appellant has no problem with that. That's not what's at issue. In this case, it's just whether or not a physical therapist qualifies as a physician.
Can I follow up on the physical therapist aspect? What kind of treatment was Mr. Ortiz, that's a male, isn't it?
Yes.
Mr. Ortiz. Was he getting physical therapy treatment? Is that
Yes.
what the PIP benefits were for?
Yes, he was. And so I take it that the conclusion that you might make based on the fact that he was receiving physical therapy treatment is that it would make sense for a physical therapist to examine him.
Not just makes sense. Isn't this required under Chapter 90, Section 34M, that the expanded definition, that you got to seek an opinion of a practitioner registered and licensed under the revisions of, 112, and isn't that included?
Well, Justice Duffy, that section actually pertains to the review of the records. The statute does use the word physician instead of a like practitioner in the section concerning independent medical exams. I think, in fact, if you look at 243 CMR 2.01, that regulation controls and defines the practice of medicine, and it specifically includes independent medical examinations as being a task or an endeavor that's included as the practice of medicine. So, and the statutory licensing requirements for physical therapists prevent or prohibit a physical therapist from practicing medicine.
This isn't about practicing medicine or even advertising about medicine. This is about the PIP statute, which has as its goal expedited bill paying for certain, if you meet the requirements, right?
Yes,
So what
and
would
so
be expeditious about requiring doctors to do doctors as you define them as compared to those providers who are actually providing the kind of treatment that the person's receiving? Don't you look elsewhere in the statutory scheme to draw from that what might be meant as to who would constitute the person who's required to examine the individual?
Well, first of all, you could look at the section that concerns the review of records where the word practitioner was used, and then look again to the section that we deal with here today, the IME section, which does use the word physician. So clearly the legislature was, it chose to use the word physician in the IME section as opposed to the records review section. And the records review section does get to your question, Justice Duffy, because there are other options for insurers. They don't necessarily have to send someone for an IME. They could have a physical therapist review the records if they wanted to make a determination regarding the quality of the treatment. A physical therapist is authorized under the PIP statute to review the records and make that determination. There are other methods, or they could, in fact, consider hiring a medical doctor. And then everyone would be assured that the highest authority had evaluated the individual, the highest authority in the medical field framework had evaluated the individual and made a determination. So I don't think it will really necessarily impede the expeditious payment.
Can I ask you on that sort of same point, that the next paragraph in 34M says that PIP benefits due from an insurer assigned shall be due and payable upon receipt of reasonable proof of blah, blah, blah incurred, provided upon notification from a licensed physician. So what does that mean? Did your client give notice from a licensed physician of his injuries?
Well, that is the issue that was addressed in the Knight case. I think the lower court did make a determination that physician, for the purposes of a certificate of disability, does mean a medical doctor, and the Knight case is a 1998 appellate division decision. But
So what does
so-
the Knight,
so we-
tell me what the Knight case holds? It
Well,
doesn't,
the-
it holds that it doesn't have to be, right?
Right, it did broaden the definition of physician for the purposes of the certificate of disability.
Right, well, but I mean, for the purposes of the certificate of disability, not only does it says a physician, it says a licensed physician. I mean, wouldn't that, to interpret that to mean a physician licensed as a medical doctor, wouldn't that also create major delays in the payment and processing of these kinds of claims?
Well, that's why the Knight court went on to broaden that definition with that statutory purpose in mind.
Why shouldn't we do the same with the paragraph just above? Which talks not about a licensed physician, just examinations by physicians.
Well, keeping in mind that same statutory intent and considering the cases that are relied upon in the Knight decision, it follows to have a broader definition for the certificate of disability, and I have to point out the Knight case only dealt with chiropractors, so it was only broadened to the extent that a chiropractor qualifies as a physician for a certificate of disability. But again, the overwhelming theme in the Knight case is that we don't want to force a chiropractor to have to get a certificate of disability from a medical doctor. Instead, we authorize a chiropractor to be a physician for the purposes of the certificate of disability, and then provide treatment to someone, and that would prevent delay. Now,
So could you, before your time is up, address the injury question, because that's a big point that the insurer makes in the case.
absolutely, yes, thank you. We do sufficiently allege injury in the complaint. That was, according to the lower court, the failings of the complaint, but if I could point the court to the allegations in the complaint, which are the complaint is the first document in the appendix. The allegations or the averments in the paragraphs 14, 18 through 19, and 37 through 41 all do lay out our averments concerning the damages. And the damages in this case are that the individual and the class of people he represents had to prepare for the IME, had to travel to the IME, had to submit to an IME, meaning a physical examination of their bodies.
But this,
They were going to
this-
do that anyway, right? So,
Well, only, so that is the hypothetical situation which has been pronounced or given as a reason by the appeals court and the lower court. I think it's improper to consider a hypothetical situation, as this court made clear in Rhodes. We don't need to speculate about a hypothetical situation, but just to cover it anyway, if the defendant had, and I think this is what you're getting at, they would have anyway if they had to, like if the statute required that they appear, or if it was actually a medical doctor, when in fact in this case it wasn't. Well, again, that's a hypothetical situation. If it was a medical doctor, yes, they would have likely appeared, and they would have been required to. But again, in this case, it was a physical therapist. It wasn't made clear that they didn't have to go. And so in the hypothetical situation, if it was a physical therapist and he wasn't qualified as a physician, then they still should have informed our client that
I get
they didn't
that.
have to go.
I'm just trying to figure out what harm did your client suffer. The finding here is that there's no complaint about the exam itself. Nobody suffered any broken bones or anything.
Well, again, it goes back to the main issue of whether or not a physical therapist qualifies as a physician. Our position is that they do not. And so taking the time out of his day to go and submit to an exam that he didn't have to go to is the damage. I mean, he didn't desire to go to the exam. It was something that he didn't have to do, and he went to and submitted to when he didn't have to. And the damages are laid out in those affirmance of the complaint.
All right, thank you. I'm afraid your time is up.
Thank you, Your Honors.
Mr. Chief Justice, Associate Justices, may it please the court, my name is Mark Ventola, and I represent the appellee in this case, Examworks. As you know, this case was dismissed by Judge Billings in the trial court, and I think in looking at this and in briefing this, there are at least 4 ways in which this court can uphold the dismissal, only one of which would require the court to sort of wade into the issue which was just discussed extensively,
Well,
and that is
shouldn't-
what's the meaning of physician.
Well, shouldn't we, though? I mean, if
Well-
it's causing confusion,
I think you should, and I'm sure that's why the court took the case from the appeals court. And I think it is an important issue in the industry. As you know, at least 3 amicus briefs have been submitted. So I think, yes, the issue should be decided. There are a lot of cases that ride on this, and so it should definitely be decided.
Is there anything in the record as to how long this practice has been going on?
I think some of the amicus briefs address that, and particularly the one from AIB, the Associated Insurance Bureau, addresses that.
well,
I
it says
don't
that
think there's
the
anything.
word physician appeared since 1943 or 44, and so, I mean, obviously not in the PIP statute, because that's 1970, but in a similar situation is what it says.
To address that point, the word physician appeared in the original statute enacted in 1970, in particular in reference to the practice of performing IMEs. So we know that word was there initially in the first enactment of the statute. After that, about 2 years later, came the phrase licensed physician, which is what the statute refers to and uses when talking about the need to have a certificate of disability from a licensed physician. That certificate then triggers this 10-day payment requirement, which ties into one of the main purposes of the statute, which is the prompt payment of medical benefits that are incurred on behalf of injured plaintiffs.
So as in practice, is that, I'm sure this was just said, but I've missed it. In practice, is that certificate of disability always signed by a medical doctor?
No, in practice, Your Honor, it never is, and that was actually the issue in the Knight case.
In the Knight case, okay.
And in the Knight case, the insurer refused to pay benefits because there was not a certificate signed by an MD. The appellate division considered that and said, no, this statute, looking at the purposes of the statute, understandably, it is not the most well-drafted. There are at least 3 different ways that the statute refers to medical providers, but looking at the statute, looking at its purposes, we cannot require in each instance a certificate from an MD, which was the argument made by the plaintiff appellant here, the argument made in Knight. We cannot require a certificate of disability from an MD in order to trigger that prompt payment. It would add too much to the system. It would add too much cost. It would add too much delay. So
Let's assume that physician does not mean MD. What does it mean?
I would suggest, Your Honor, that it means one of 2 things. It either means, as some of the amicus have suggested, one skilled in the art of healing. That's certainly one of the accepted definitions. When a statute does not define a term, certainly we see the word physician elsewhere, and it's defined elsewhere in the general laws, but in this particular statute, there's no definition.
So that could include homeopathic practitioners, it could include acupuncturists, it could include, let's see, it can include
Massage
naturopathic.
therapists?
I would suggest, Your Honors, that it is those licensed under Chapter 112 to provide some form of medical care.
So you would say medical professionals licensed under Chapter 112?
That's the way I would read it, because those are the types of people that, and providers that those injured in these accidents will see. They might see.
Of course, one of the problems is that the statute that we're talking about, I think, also says that if there's a review of the records alone, it can be by a correlative provider. So that the legislature has made that kind of an adjustment for purposes of record review only. But where there's a physical exam, they use a different word. They use
Right.
physician.
They do. As I said, they use 3 different words through the course of the statute. The one Your Honor was just referring to is what I would call a paper review or a medical review, where just the bills or just the records are being reviewed cold, without an examination. And it's in that case, and this is the most recent amendment to the statute, the one that happened in 1989, where the legislature added the second sentence in the 4th paragraph saying that if an insurer is going to do just a medical records review, a paper review, then in that case, what needs to happen is that review, if benefits are going to be denied as a result, has to have occurred by someone licensed under the same statute as the person who is providing the services.
Well, but it's, Chris, it seems that one of the problems that arises out of your model is that if a person has complicated internal injuries as a result of a motor vehicle accident, can a physical therapist competently make a recommendation that benefits be terminated?
I don't think so, Your Honor.
But that would be permissible under your model.
Actually, I think it would not, Your Honor, and I think this court addressed that very issue in the Boone case. The Boone case came very close to deciding the issue that we're here to talk about today. In the Boone case, the question there was the treatment was rendered by a chiropractor, and the examination was performed by an orthopedic surgeon. This was an independent medical examination by an orthopedic surgeon. This court recognized that there will be situations in which there is overlap between the different specialties or the different licensed requirements. There'll be overlap between what a chiropractor does and what an orthopedic does. But the court also recognized that there are limits. That's what the licensing statutes are designed to do. No medical professional is going to step outside. That would be the unauthorized practice of medicine in that particular instance. If a physical therapist were stepping in and providing some type of examination and or opinion about serious internal injuries, that would be beyond the scope of what, under this licensing statute, the physical therapist would be allowed to do.
So in this particular case, if in the course of the physical examination, the plaintiff had displayed certain symptoms that were kind of inconsistent with physical therapy, in fact, symptomatic of something far more serious, what should the physical therapist do?
Yeah. In fact, Your Honor, under the regulations that deal with the practice of medicine, an IME is considered, if you will, the practice of medicine. There's been some question about that because it's really, if you think about it, not so much of a doctor-patient relationship, but in a situation like that, the referral should be made. The physical therapist has a duty to notify the patient and to make them aware that perhaps there's something more serious going on than the patient may be aware of. So I think that would certainly be what should happen.
On the statutory issue, there are a variety of statutes, not this one, where the word physician is used, where the legislature has taken pains to say by using the word physician, we mean to include A, B, C, D, and E. Right. So how are we supposed to read the absence of anything like that here?
Yeah. The problem with this statute is, and I've tried to figure this out, whether there is a consistent way of looking at other statutes and importing them, if you will, into this statute. And I think because of the way this statute has been constructed over time, 1970, then an amendment dealing with licensed physician, inserting that word in 1972. Then in 1989, with respect to these paper reviews, using yet another phrase, same practitioner, and referring to practitioners. It's near impossible to take any meaning from other statutes as to what the word physician should be in the context of this particular statute. So I think what we need to fall back on is, what's the purpose? What is the purpose of the statute, as the court has previously discussed? And it was to provide, prompt payment of medical expenses, to try to create systems that drove down what at the time was skyrocketing insurance costs. And
Don't you think that the worry is not so much in, I mean, here, Mr. Ortiz was actually paid. I mean, got the PIF benefits, right?
I'm not sure that's in the record, Your Honor, but I believe so.
I thought it was.
Parties talk about it a lot.
Yeah.
Yeah.
Isn't the concern more that the, that the wrong level of caregiver will make a negative call? You know, not entitled to benefits.
Yeah.
And then what do you do?
Yeah. Again, Your Honor, I think that if what that comes down to is a question of whether, and I guess I would use the phrase that the appellant used, we have the highest level of provider. I think the level of provider is dictated by, and what the provider who's going to do an examination will be, is dictated by the nature of the injuries and the type of treatment that they're receiving.
You can have
Because that's already happened. That's already happened. There's already been a certification of some sort of a disability. There's already been treatment, and now the question is whether it was appropriate.
Correct. And in some instances, the treatment is ongoing.
So this is not a question of someone being injured and being told, before you can do anything, you need to come to our IME to assess your injuries.
Generally not, Your Honor. Generally, the way this runs is that because it's an auto accident, the injury occurs, the treatment is rendered and begun, and the process catches up, because the person has to remember that the person who's injured has to apply for these benefits. The insurance process has to begin to play out. And so, of necessity, these independent examinations are taking place, and they do not occur in order to approve treatment. They're just generally occurred to find out if the treatment that's happened is reasonable and necessary, and if more treatment may be required.
So there's already been, presumably, a medical examination by this person's doctor or at a hospital or someplace, and that's what triggers the whole process.
In all cases. The process would not even begin unless the person had already received treatment and applied for benefits.
Can I ask you, how does Examworks work?
And this is interesting because while I'm defending the insurance industry here, Examworks is not an insurer. Examworks is an independent company that when an insurer decides they would like to have one of these independent medical examinations or one of these paper reviews, Examworks will have a roster of medical healthcare providers in all areas of specialty that will be available to perform the examination.
Does the insurer say, we want a chiropractor to do this, or does Examworks look at the services provided and select an appropriate professional?
Again, while this is not in the record, the way it works is that the insurer will in all cases dictate what it is that they want.
What level of medical professional should look at this?
Because at that point, the insurer has received the PIP application and possibly already some of the medical records, and will see what is needed and make the determination.
Now, in this case, did Mr. Ortiz go directly to a physical therapist, or did he go to a doctor who referred him to a physical therapist, if you know? Or does the record show?
I don't know from the record, Your Honor.
Would it make a difference in terms of who was appointed to be the IME?
It would depend. I mean, the purpose of the IME is typically to determine when there's ongoing types of treatments, such as physical therapy or chiropractic, where there are multiple visits, or acupuncture or massage, that type of thing. And these are typically in the soft tissue type injury cases, whether the continuing treatment over the course of many, many visits and many, many months is reasonable and appropriate, because it is not in all cases. So if the person had initially seen a medical doctor, which is often the case, they'll see a medical doctor in an emergency room, or perhaps a primary care physician that prescribes physical therapy or some other type of therapy that would be continuing, then it would be the continuing nature that would dictate what type of exam. So if it's continuing chiropractic, that would be a chiropractic exam. I see my time is...
You have 1 minute to tell us the other 5 reasons why you win.
I'm going to say just one thing. I've briefed it all thoroughly, but I would say that the one thing that was clear to me in looking at this case is that there are 2 claims. One is for invasion of privacy under Chapter 214. The other is an unfair and deceptive practices under Chapter 93A. At the time this exam was performed in 2011, Based upon the state of the law, it seems to me that no one could reasonably say that an insurer or a company such as Examworks performed something or engaged in some practice that was unfair and deceptive in arranging for a physical therapy medical evaluation, when the state of the law at that time, based upon the Boone case decided by this court, based upon the Knight case, those two cases, clearly, if an insurer was looking at those, would say, these types of exams are allowed. This is exactly what the statute is designed to do. The same for the invasion of privacy claim. There's no suggestion that based upon the state of the law, there was anything unreasonable or serious or substantial. And I see that my time is up. Thank you.
Thank you, counsel.
SJC-11507, SORB number 34186, the Sex Offender Registry Board.